Team here at Owen Mitchell, and I'm joined by my colleague Andy Boyd, who will be also presenting today. So today's about helping you understand what's coming up in the Employment Rights Bill. A word of warning, though, we don't have all the answers and we can't possibly get through the Employment Bill in an hour. So today is just to set the scene, let you know what we're expecting, what's coming up, and more detail will be following. So we'd really encourage you to take from today some of the key insights and then keep in touch with us. We are expecting a lot more detail in terms of how these frameworks are going to work, and we'll be doing a much more detailed webinar later in the year. But you're entirely right to sign up to this and listen in, because you need to know what's coming so you can start to prepare. So this webinar is directed predominantly at those individuals or businesses who are intermediaries, and by that what I mean is you will no doubt be working as a consultant or another organisation supporting businesses. So we're hoping that you will take away some insights so that you can have some engaging conversations with your clients and contacts and help them get ready. But we've also got some people who are businesses in their own right signed up today. So you're all very, very welcome, and you will also get some really good insights today. So you can see on the slide our speaker details and our QR codes. Lisa, can you just bob back 1 second? Thanks. Please do take a moment to link in with us on LinkedIn using those QR codes. And if you've got any questions whatsoever, you are more than free to contact either myself or Andy after the session today. Okay, next slide then. So by way of a bit of a background, Labour proposed to make work pay, and by that, when it came into government, it made a wide-ranging number of proposals, some of which were controversial, under the Employment Rights Bill. And we got the detail of that last autumn. It essentially provides a legal framework of key changes. And as I've said already, much of the detail will be coming through. We're starting to see that land very recently, and expecting a lot more to come over the course of the next few months. And that's because they've made some broad sweeping proposals, but we need to make those into law. And those laws will be regulations, which will set out the detail of exactly how it will work. And there will be some consultations, and have been consultations with businesses and key stakeholders over the last few months to try and understand what those impacts of the proposals will be. And then obviously they need to work themselves through Parliament. So a lot of the changes that we're talking about will not actually come into force until next year, 2026, but some will, and we're expecting those to impact later in the year. But just because they don't come into force until 2026, it doesn't mean to say we can rest on our laurels and do nothing. We're going to go on and talk about some of the key changes split between Andy and I. So unfair dismissal rights is a massive change, which Andy will cover. As is the additional rights to people working under casual contracts, so agency staff and 0-hour contracts. I'm going to talk about the duties in relation to harassment and some of the duties that have been in place for the last 6 months and will be increased as well as what we're expecting to see in terms of increasing trade union rights. And then we'll also talk about changes with flexible working and collective redundancy. So today we'll give you the highlights of what to expect, but some of these things you need to start putting in place some measures so that you are ready when these things hit next year. Next slide, please. So first of all, I'm going to talk about harassment. Last October, there was a piece of legislation that came into play, which specifically put the obligation on employers of all sizes to proactively prevent sexual harassment in the workplace. And on the next slide, you'll see some stats. These came from a survey by the Equality and Human Rights Commission, which concluded that 75% of workers have at some point in their working life experienced sexual harassment at work. And this is despite legislation being in place since the 1970s to prohibit sexual harassment in the workplace. Now, around 50% of those that had experienced sexual harassment at work didn't report their experiences. So just the takeaway from that is just because you think it might not be happening in your organisation because it's not being reported, doesn't necessarily mean that it's not happening. And concerningly, senior colleagues are often deemed to be one of the more common perpetrators, and also third-party harassment is a significant issue too. So the government, and this wasn't just a Labour initiative, it was something that the Conservative government had also proposed. It was felt that we needed to do more. So we needed to put some obligations on employers, not just to respond to sexual harassment and have a policy to say we have a zero tolerance to and we'll deal with it when it happens. We're now under a positive duty to actually prevent it. And that duty is about reasonable steps. And I'm going to talk about a bit what those are. And I've been working with a lot of organisations over the last 6 months to ensure that they are starting to make those reasonable steps. But this is going to step up a pace over the next year or so, which I'll explain as well. Now, at Irwin Mitchell, we did our own tribunal analysis just to see where the movement is on these kind of cases. And, you can see since 2019, the number of cases have been increasing. And that, of course, is a trend that we would expect, not least because of this legislation, but because of quite a lot of publicity that we have seen over the course of the last 5 or 6 years, which have highlighted the very real issue that sexual harassment in the workplace is. So next slide, please. So as I say, we've had some legislation in place since 26th of October last year, which places all employers under a duty to take reasonable steps to prevent sexual harassment. Now, we have put some content out there to help you with this. And my colleagues are just going to put into the chat an e-book, essentially, which will help you with some top tips on how you can start to make some reasonable steps towards preventing sexual harassment. And these come from the technical guidance in the Equality and Human Rights Commission's guidance, as well as our own thoughts. And I've grouped those into the core themes that you can see on the slide. So looking at your culture, do you have a culture of harassment and sexual harassment, or whether you know about it, or is it a risk? Doing a risk assessment is absolutely key, and we can help with those should you or your clients need some assistance. What your policy is saying, how much are they being updated recently? How much of a presence does sexual harassment have on those policies? And what training have you done? It's not enough just to have policies that are written and hidden away and not very accessible. We've got to make them accessible, and we've got to make them have meaning. So training to your staff about what sexual harassment is or could be, as well as training to your managers to empower them and give them that confidence to recognise it themselves and deal with it appropriately, is absolutely key. And that ebook that we've put into the chat there gives you some information about some of the tools that we've got to help you with that, including some e-learning, which has been extremely popular over the last 6 months and very cost effective if you were interested. So think also about, beyond the training, how complaints are raised and how there can be a confidence in that process. Remembering the statistic that I said that over 50% of people who'd experienced sexual harassment hadn't actually raised it. That's something that we need to overcome, as well as them monitoring how all of this is working effectively. So next slide, please. The reason why it's important that you do this is obviously if you're doing these steps, hopefully you will not be in a position where sexual harassment occurs within the workplace. But if it does, if it's complained about and a claim is made, the claim of sexual harassment is simply put, somebody needs to show that unwanted conduct of a sexual nature has taken place, which has had the effect of making them feel upset or intimidated, or they've suffered some type of other less favourable treatment in relation to it. And if you cannot demonstrate as an employer that you have taken reasonable steps to prevent it, then the liability and the compensation that would be awarded ordinarily will be uplifted by up to 25%. Now, when we're talking about discrimination, you can be looking at quite significant damages. So you could be looking at loss of earnings for one thing, if somebody's left as a result of sexual harassment in the workplace, but also they can bring an injury to feelings claim. And the damages that can be awarded for that can exceed up to £50,000 now in the most severe instances of sexual harassment or other discrimination. So our 25% onto that, we're talking serious sums of money. So it's really important that you are looking at this. And the Equality and Human Rights Commission can also go in and do their own investigations. And indeed, they have with organisations that you might well have seen in the press, such as McDonald's and IKEA, who have both been reported to have a culture that needed addressing. And they've had to engage with the EHRC to put in place some measures to prevent harassment going forward. Next slide, please. So that's the current law. This isn't new. This has been in place since October, and the expectation would be you would already be making steps in relation to this, or your clients would be. And if you need any help to understand if you've been doing enough or you need to be doing more, then like I say, please do reach out to Andrew, and I'm more than happy to help. But it's really important that you understand also that the Employment Rights Bill is going to toughen this up even further and will require employers to take all reasonable steps. Now, all is quite a small word, but it means a big step up. Currently, it's a duty to take reasonable steps. Taking all reasonable steps is going to put additional scrutiny on the organisation to look at, well, what steps could you have done and why haven't you taken all of them? It'll look at it assessed against the organisation, but ultimately it's going to be the tribunal that decides, by which time it's too late, because if they decide you could have done more and haven't, then there's going to be liability there. So start to tackle this now, because it's not something that will correct overnight. And, you know, I've had some clients say, well, we don't really want to start talking about this because it might show that we've got an issue and we don't think we have. Well, you can use the fact that you've got these new duties to create the reason to start the conversation, really. So I really would encourage you to be thinking about this and doing something about it, or talking to your clients to ensure that they've got something in place. Next slide, please. And on the topic of harassment, it goes a stage further under the Employment Rights Bill. There's been a lot of talk about how we can tackle third-party harassment for some years, and it's a tricky one. But the Employment Rights Bill says that it will reintroduce liability for employers where their staff have been harassed by a third party in the course of employment. And where we're talking about third parties, we're talking about customers, clients, patients, if you're in the medical sector, service users. If you're in education, it might be students or the parents. And it could be, well, it could be anybody who's not a colleague, effectively. And if you just think about, you know, you only need to go and catch a train and you can see the adverts, can't you, of the staff saying they've been subjected to harassment in relation to service users and passengers. And we know in the education sector, it's becoming a massive issue from a students and parents perspective. And in the retail hospitality industry, you know, you've got customers and also third parties of organisations you might work with. So there might be at a conference, you might be dealing with other companies who supply services to you, or you supply services to them. And harassment can occur in that instance. And harassment can be very low level and it can be more serious, but it, you know, and in the course of the work, employment does stretch out to evening hospitality events, events where there might be drink involved, where that boundary can become a bit more loose, I suppose, and people think they can you know, let their standards down a bit more, and that's not the case at all. If it's a workplace environment or it's a work organised event, it is still in the course of employment, and that extends also to parties and such like. So the government is wanting to tackle this. And essentially what this is going to mean is if you know that this harassment is happening or is likely to be happening in those environments, based on your own risk assessment, you need to be taking steps to prevent it. Because if you don't, you might be liable for that third party's actions. And you don't need prior notice that it's happening. You need to do your own risk assessment of where it might be happening. So you need to be thinking of how you can be engaging with those third parties, how you can be preventing it if you know about it and stopping it, how you can be empowering your staff to know that it's not acceptable and that they can, with confidence, come to you and tell you that it's happening. So this is something you really need to start planning ahead for now and thinking about those risk areas. What I would say is that you still can be liable for third-party harassment to an extent currently on a sexual harassment side. If you know it's happening and you take the step, or you don't take any steps to manage it, you could still become liable at the moment. But this is about all harassment, not just sexual harassment. We are going to be doing a separate webinar in relation to this specific topic because it's tricky and it needs a lot of thought. So if you don't already sign up to our webinar invitations, please do make sure that you do, and you'll get the details after this webinar today to help you sign up to that. That session's due to take place in June. So that's a save the date where we'll talk much more about this duty and what it means and what you can be doing to prepare. Okay, next slide, please. And I think this one is quite obvious. The key risk for businesses, if you get this wrong, it can affect your recruitment, retention, your reputation. It can lead to damages, legal cost, as well as disengaged staff. So please do take that one seriously. And like I say, there's more to follow on that. Next slide. I think I've covered all of those. So next slide. Onto a completely different topic, I'm just going to finish my slot talking about industrial relations and collective consultation stages, collective consultation under the Employment Rights Bill. So there are some really big changes afoot in relation to trade unions and the presence and power that trade unions will have within a workplace setting. The employment, we don't know the details of how this is going to work, but like I said at the beginning, more will follow throughout the course of the year. The bill makes it clear that it wants it to be easier for unions to call strikes, get access to the workplace, to recruit and organise their members. And with that, it wants to increase their visibility. So one big change, which will affect all employers, is that all workers must now have a written statement or will, when this comes into law, that says that they have a right to join a trade union. And trade unions will also have the right to request access to come into the workplace to engage with staff as well. Ultimately, what this is going to mean is that you may well see increased appetite for union recognition or support for unions, such that you might then need to be in a position where you are entering into voluntary arrangements with the unions to agree how you're going to consult and negotiate with them on certain key matters. Currently, employees are protected if they take part in lawful strike action and then are dismissed in relation to that. But they don't, the level of protection given if they suffer any other detriment, which is short of dismissal, isn't nearly as strong. It's not there. And that's going to change too. So not only will we see unions be more, excuse me, more present in the workplace, we'll also see employees getting more rights in relation to detriment should they support union activity in the workplace. Next slide, please. We don't have a lot of detail of how this is going to look. So I think for now, all I can give you is some key takeaways. And I'm very conscious that on the of the businesses that are attending today, this will maybe be a massive thing because you already have a lot of union interest and relationships already, and some may not. But just take away that we know that this is coming and we need to work hard at the existing trade union relationships we've got, improving those relationships, improving the agreements we've got in place. And if you don't already have this, then you just need to be aware that this is coming. And as I said, more will follow when we know the details. Next slide, please. And then finally, for me, I just wanted to mention about collective redundancy, because this is another big change that is coming through. So currently, where you are making redundancies in an organisation of less than 20 employees, we're not talking about collective redundancy. It's a much more simple and straightforward process. Collective redundancy is where there are 20 or more employees at one establishment. So that's one particular workplace currently. And in that instance, there's a duty to collectively consult. And by that, what we mean is you have to consult with employee representatives, and there's a minimum period when that consultation has to take place before you can even go down making any proposed any dismissals. Now, what the government is wanting to do is extend that trigger. So it's been going through some consultations in relation to how it does this, and the recent update is as set out on the slide. So where there are 20 or more employees at one establishment or across the whole of the workforce, so that might not mean that one particular office location, it could be much broader, there's a threshold number of employees that is hit. We don't know what that threshold will be at this point. But I suppose the easiest way of looking at it is you might have a number of offices, and in each office there might only be 10 people being made redundant, which currently would mean that you're not triggering the collective consultation. But if as a whole those numbers together for the organisation hit that threshold, then you would be into collective consultation. So it's going to have to mean you're not just looking at that one particular workplace, you're looking wider across an organisation, which, depending on the size of the organisation, may be easier than others. It's going to mean that there is a likelihood that collective consultation will be triggered more widely, and with that then comes some additional responsibilities, and if you get it wrong, some additional penalties. So if you are thinking that in the next year or two you are likely to be making quite significant restructures which could affect the need of particular employed roles, or closures of workplace and such like, it might be worth just exploring what you need to be doing now sooner rather than later. But as I say, we'll get more details in relation to these thresholds, but you need to understand what these triggers will be. Okay, next slide. And I mentioned about the additional penalties. So currently there is a protective award that applies if you do not properly comply with the duty to collectively consult in relation to redundancies. And that's a 90 days pay award for each employee who is affected. And the government is proposing to increase that to 180 days. So it's doubling. It's also going to remove the cap. There's a current cap on that amount. And so it's going to be more expensive effectively if you breach it. It's also considering the ability for employees to claim interim relief, and effectively what that does is enables an employee to put a stop or get some compensation for the interim period while they're saying that consultation hasn't been happening. So without overcomplicating it for the purposes today, just be aware that there are some big changes in relation to those larger scale redundancies and trade union rights. And if you are worried and think this might affect you and want to just scope out what that means for you and what you can be doing to prepare, please do get in touch. But as I say, more detail will land in due course. Next slide. And I've covered that already. Next slide. On that note, I'm going to hand over to Andy to talk about unfair dismissal, which is probably the biggest one that's hit the press, and it's going to be a big one. So over to you, Andy.
Thanks, Jenny. Yeah, absolutely. Definitely the headline grabber. So we can just move to the next slide. So in terms of this unfair dismissal right, it's currently at 2 years, and that's going to come down to a day one right. So as the slide says, the employers are still going to need to have a fair reason and follow a fair process before dismissing an employee. So the fair reasons haven't changed. So their conduct, capability, redundancy, illegality, so that some of the substantial reason. In terms of a fair process, however, what the bill introduces is what's called initial period of employment, which isn't the easiest thing to say. So for the purpose of this webinar, I'm going to refer to that as a probationary period. This probationary period is going to have a maximum length we understand to be 9 months. And in this initial period of employment, so the probationary period, there's going to be a light touch process in terms of a dismissal. The only one of the fair reasons that wouldn't come under that banner would be redundancy. So they'd still have to follow a full process for that. There's going to be a lot of consultation to come in relation to this, and that will come under draft regulations. So in relation to the light touch process, we're not clear quite yet what that's going to look like. So we just go on to the next slide. Previously, in a former life, there were statutory dispute resolutions, and they probably weren't the best process that could have been followed. So there's going to be real consultation on this, but we'll have to have tribunals decided what is reasonable or unreasonable dismissals, and the fair reasons, the fair process follows. What we can be clear on is at the top of the slide there. So notice must be given before the end of the probationary period, but notice can expire up to 3 months after the end of the probationary period. So one of the sort of takeaways from this is, if we just flip to the next slide, is that a lot of employers moved away from probationary periods for cultural reasons. They sort of were relying on that they'd made good hires and they shouldn't need to have those probationary periods. So I think that's something that we need to go back to. So in terms of the contracts, if someone's got a probationary period, we think it will need to go up to 9 months, and then within that 9 months there'll be that dismissal sort of light process. It's likely that the ACAS code of practice will need to amend it to sort of a two-tier approach, the full process, and then obviously the dismissal light, which excluding redundancies could be followed for all the other fair reasons. The things that you need to be really aware of is that under the bill, the limitation period is increasing from 3 months to 6 months. So that's going to catch a lot more claims. So the takeaway really is going to be there's going to be an increased volume of tribunal claims. There's talk of the compensatory award being capped for unfair dismissals during this initial period of employment, that probationary period. But obviously that remains to be seen. But that's not going to sort of drive right through automatically unfair claims which are already there, e.g. whistleblowing or maternity discrimination. So if we just move on to the next slide about the key takeaways. So I'll run through those. So it's definitely going to be more difficult for employers to dismiss employees with short service. The recruitment process is going to be even more important. So we need to get the right people through the door. And then once we've got the people in the building, we need to set clear performance expectations at the start of employment and a culture of meaningful review. So we get a lot of clients that come to us and say, oh, this person's performance is terrible, but they've not addressed any of those issues. They've just let them mount up, and then they want to just basically, with a click of the fingers, dismiss someone because they're a poor performer. So we need to get better training in place for managers. And Jenny will come on to talk about our sort of back to basics training offering, which is really important for line managers to be comfortable having those difficult conversations and be really good at doing meaningful review and appraisals, probably at the 3, 6, and obviously 9 month marks. If we can just move on to the last slide. So that was a sort of whistle-stop tour of the unfair dismissal. So I think the real takeaway from that is the extended limitation date of 3 to 6 months is going to be key. And then what the dismissal light process is going to look like and what process will follow. So a lot of consultation will come through about that. The sort of risk adverse advice would be to follow, a good dismissal process in the first instance, which I think a lot of our clients do anyway. And that's what you should be advising your clients to do. Always at least provide written reasons for why there's been a dismissal, not just taking that real commercial view. So we can just pop on to the next slide. I might make no apologies about how complex this next area is. So I think the sort of underlying reasons for the government bringing this in was to basically have a baseline level of security and predictability for workers, those that were particularly vulnerable. So those being on 0 hours contracts and low hours workers. The bill is very, very complex. And what I will try and do is explain how it's going to work. So if you've got a low hours worker, and I'll come on to that on the following slide, what that is, they need to be offered guaranteed hours. How that's going to be calculated is on basically a 12-week cycle. So if they've worked for the previous 12 weeks, at the end of that reference period, which we understand is going to be 12 weeks, they would average out the hours. And if they're working high volume of hours over what their contracted hours are, then that's going to be the guaranteed hours they're going to be offered as essentially a variation to their contract for going forward for the next period. This cycle is going to continue and continue until they reach that minimum level. So we can just move on to the next slide. So unhelpfully, the $1 million question is, what is a low hours worker? So it's not defined in the bill, and that's going to be set out in the regulations. The purpose of it was an anti-avoidance measure from the government. So they just didn't want people that had employees on 0 hours contracts to just put them on sort of 1 or 2 hour contracts. As I said, once they fall out of that definition, the rules are no longer going to apply to them. But what's going to be really important is what the low hours contract threshold is going to be. If it's set too high, it's just going to limit a business's ability to adjust the staffing levels on short notice, and also the administrative burden of that, which I'll come on to at the takeaway at the end, is going to be a huge consideration for your clients. So on to the next slide, please. So the default position is that the offer is going to be for permanent change to workers' terms and conditions. So if we, for example, said that 15 hours was the threshold and someone was on 5 hours in the first reference period, then 10, then 15, as soon as they've reached 15 hours, then they'll have reached that threshold. There doesn't need to be that continuous cycle. There's also going to be circumstances which are referred to limited term contracts. So if I just read out what those are going to be, and you might in your heads be thinking about how these might apply to some of your clients' businesses. The purpose of these was for if there's unusually high levels of work and it's inherently temporary. So some of the examples would be the sort of the peak retail season leading up to Christmas, for example. So retail and hospitality. So the sort of three carve-outs the government have come up with is the workers only need to perform a specific task, and the contract provides that it will be terminated when the task is performed. The work is only needed until the occurrence of an event or failure of an event to occur, and the contract provides it will terminate on occurrence of the event. Or finally, there's only a temporary work need, and the contract provides that will be terminated when the employer reasonably considers that the need for the work has come to an end. So in terms of what that might look like, is that it sounds like employers are going to be able to offer these limited term contracts. So that, as I say, back to that example of the run up to Christmas, those retail and hospitality, the leisure industries, they should be able to offer those. There's going to be no need to make any further offers in the circumstances where an employee is fairly dismissed, obviously following the process we talked about earlier in the slides, or they resign during a reference period. Similarly, if that limited term contract I've just described comes to an end. Again, we need to be mindful that the claims limitation period is extended from 3 to 6 months, and a worker who's not offered hours on the required terms can bring an employment tribunal claim. So another piece of legislation that employers will need to be wary of. So in terms of what that might look like, so if it was successful, a tribunal might be able to make a declaration, then make an award for just and equitable compensation based on final financial loss of the individual. That will be subject to the usual mitigation, but the guaranteed hours that should have been offered. And again, the maximum award is likely to be capped, but again, we wait for further information on the regulations. Can we just move on to the next slide, please? So just for clarity, at the moment, only employees will have the right not to be unfairly dismissed because they have accepted or rejected an offer and have the right not to be subject to a detriment, and those dismissals for employees will be automatically unfair. So again, significant additional burden for employees, and these new employment tribunal claims will mean inevitably there's going to be an increase in employment tribunal claims. Just move on to the next slide, please. This I'm not going to spend too much time on, but this is going to be an absolute administrative burden and minefield for your clients. So the bill's going to create 3 new rights. So the first being reasonable notice of shifts, the second being reasonable notice of shift changes or cancellation, and then probably most worrying for employers is payment for cancelled, moved or shortened shifts. So what is reasonable is probably, again, the million-dollar question. So that's going to depend on the circumstances. That's going to be fleshed out in the regulations, but it's likely they're going to set a minimum time before the shift is due to start. So we know it's going to be less than 7 days, but it might be 2 days, it might be 1 day. But I say this is a very complex area, and given the sort of nature of this webinar, I'm not going to go into too much detail on that. Can we just move on to the next slide, please? It's probably the real driver behind this is to protect low-paid workers with unpredictable working patterns. So what we are likely to see is a maximum salary. So those that are on sort of low hours but are really highly paid, or a maximum number of guaranteed hours. So if it sort of goes above those thresholds, then these instances are not going to apply. It is going to apply to 0 hours contracts, shift workers or variable working pattern workers. The bill gives the government power to specify that the provisions only apply to contracts below a maximum salary or the minimum number of guaranteed hours, as I've said. If we can move on to the next slide, please. The only point I'm going to make on agency workers is that as this went through, this was an amendment to the bill because I think a lot of employers were looking at the landscape of having to sort of offer compensation if these shifts were changed at short notice. So they were just going to rely heavily on agency workers. So agency workers have now been basically rolled up into this remit because it was worried that employers were just going to evade these new obligations. So if agency workers do apply to your clients' businesses, there's obviously more detail in the slides, and obviously you can contact us directly to look into that in more detail. So in terms of then the takeaways, there's definitely going to be further consultation. If we can just look on the next slide for that. There's going to be the right to reasonable notice of shifts, including which workers are going to be in scope, the right to payment for cancelled, curtailed or moved shift, again, including which contracts are in scope, what constitutes short notice, how much a payment will be, and any exemption. So obviously a lot to go at there. These changes fortunately aren't going to come into force before 2026, but what are the takeaways for your clients? Definitely they need to be undertaken an audit. Do they use 0 hours contracts? Do they use low hours workers? Could they potentially look at offering more fixed hours now and getting ahead of that curve? Then actually thinking through the logistics of this, how's that 12-week cycle going to apply? Again, back to the sort of retail and hospitality, do you have seasonal fluctuations? How are you going to manage engaging staff for those? What systems in place if shift needs to be changed and at short notice? And then what evidence have you got about the changes to shifts? As Jenny touched on earlier about trade unions, there could be collective agreements might be a way of getting around this if a trade union is recognised. The sort of comparison would be sort of the working time regs. That gives you a bit of precedent as to how that could work in practice. And now we just move on to the last slide on these contracts. So just the real takeaways. So if shifts are usually offered at short notice or regularly cancelled or curtailed, you need to assess how this can be improved to reduce this exposure to compensation when the changes do come in. So if you can get good processes in place ahead of time, that's going to serve your clients very well in the future. The compensation is a real threat. The consultation is going to happen, but can't be overlooked. So I think if you start looking inwards first at your own clients' businesses, that's going to be a very good start. And then do you actually need to use these casual workers and agency workers? So as I say, not much in terms of the bill is nailed on. Obviously needs to be fleshed out a lot with the regulations, but certainly it's an intention for Labour to protect those vulnerable low hours workers. So I'm going to be able to wrap up my section on flexible working. So one of the key pledges, if we just can move on to the flexible working slides, please. So if you see at the top, one of the key pledges from Labour and what was sort of in all the sort of tabloids was that making flexible working the default for all workers from day one, except where it's not reasonably feasible. That was the pledge, but what's actually sort of come out in the wash of the bill is just introducing a test of reasonableness. So a bit of background then. So the day one right to make a flexible working request came in sort of over a year ago, 6th of April 2024. You used to have to wait 26 weeks before you could do that. I'm not sure what the stats are, whether there's been a massive upsurge in those requests for flexible working. What this reasonable element to it is going to do is going to make it more difficult to refuse those requests. What hasn't changed is the prescribed reasons. So those of you that have advised your clients on flexible working will be aware of those 8 statutory reasons. So they're really sort of the business cases for why a flexible working request can't be accommodated. The pandemic showed a massive shift for people having to work from home, which obviously broke down a lot of sort of business reasons for companies as to why they couldn't entertain working from home. And now, in terms of the labour market, hybrid working is obviously in recruitment practices one of the major sells for a lot of employees looking to move. So the real takeaway from the first slide is that it's not going to be a default to work flexibly from day one, but the right to make the request has to be a reasonable one. So in terms of what the takeaway then on the next slide is, how your clients can prepare for that, is obviously expect more claims and more requests. Really do some forensic analysis of how you've dealt with flexible working requests previously. If you did decline the requests, why did you, and what was your justification for doing so? Were you reasonable in doing that? Did you apply that across the board when you got similar requests? And then in terms of the training to managers, again, that's coming out loud and clear in a lot of the changes here, especially with the probationary periods for unfair dismissal. Are managers geared up to actually deal? Do they understand what reasonable might look like in practice? So I think if that's the message you can get to your clients, is you need to be training these managers, because if that's someone walks in on day one and makes a flexible working request, can we deal with that expediently? Can we deal with it reasonably? And can we make commercial decisions about that? So that's my slides, and I'm going to pass to Jenny for her reflections on the issues we've raised today.
Thank you very much. So, my key reflections on all of this is employment law affects all businesses with employees, be that small or large. And what the employment bill is probably the most significant changes we've seen in employment law for many years. So we can't hide from it, and we need to start preparing for it. The liability of getting employment law matters wrong is only going to increase, and the prospect of employees being able to bring claims is only going to increase. Added to that, there are proposals for additional agencies. This is very recent, actually, an agency called the Fair Work Agency, which is a government body. There's a proposal that this agency will also be able to challenge and bring claims on behalf of workers in things such as where they haven't been paid their correct pay, maybe the 0 hours points, national minimum wage, holiday pay. So the ability to bring claims is going to be broader, without a doubt. So is that all bad news? Well, not necessarily. What it just means is we need to be aware. We need to think about the ways that we can minimise the risk and put in place those measures to enable us to be ready and prevent litigation. But when it does happen, that we're in a good position to defend it. And really that comes down to looking inwards, doing the risk assessments on all of these areas that we've talked about now, so you understand how much is this 0 hours and guaranteed hours point going to really impact our organisation. If you use those kind of staff a lot, it's going to have a massive impact. Equally, are you getting a lot of requests for flexible working, and how receptive are you or your managers to it? It's one thing having a policy saying that we we'll listen to flexible working requests, but if your managers don't actually understand what that means or what that statutory process is, or if there is a more of a knee-jerk response really to say that we can't accommodate it, that's going to become an issue for you. So maybe you need to start thinking and untapping, is this because that's our preference, and that preference really isn't the way that the law is moving, in which case I'd encourage you to challenge your approach in that and see it as an opportunity, because it is here to stay. Similarly, with the unfair dismissal rights that Andy's talked about, there's loads that we can be doing to empower line managers between now and then when it comes into play, which will be no earlier than autumn next year, to be better managers. And when we're doing line manager training on things such as performance management, disciplinary management, how to manage absence, again and again we hear line managers say we don't really feel confident in what we're doing, which is sometimes why the right early steps are not taken. So use this next 12 months to think about empowering line managers to do their job better, so that at the point that employees can bring day one rights claims, those basics have got into place. And then whether you're a business or you're acting for a business that's heading for sale or looking for investment, maybe they've been recently acquired, maybe you as an organisation are looking at moving premises, which can impact on redundancies. Maybe you're wanting to have a real push in your growth plan for the next 3 years to improve client service or profitability, driving that high performance. All of these things together impact on employment law. So if you're not close to employment law changes, I'd really encourage you or your clients to keep in touch. And I'm just going to go through how you can do that without any cost whatsoever in some really easy to follow ways. I've already mentioned about our webinar that's coming up on the third party harassment point. So the date is mid-June. I think it's the 17th of June, and the invitation will be ready in the next few days. We'll send details in follow-up to this webinar. So please do sign up or invite your contacts who would be interested to do so. You've got the link to the sexual harassment ebook that I mentioned. Please do forward that on. It's a free resource. You can, at the back of that document, sign up to download a free sexual harassment policy, which is compliant with the current prevention duties. So that's a free resource. And as I mentioned, there's also some specific online training that you can access at very low cost to train both employees and then separately managers. Albeit a lot of clients are asking for some in-person training for managers, which really is a good way of getting some conversation around some of these tricky issues, and we'd be happy to help with that too. So that's that sexual harassment information and third-party harassment. We do regular mailers, which keep you up to date. We're really lucky as a firm to have our dedicated professional development lawyer whose sole job is to keep us up to date and our clients up to date. So when changes are happening, she knows about it. There's two of them, Joe and Alex. So if you know, please feel free to pass on the information so your clients and colleagues can sign up to those e-briefs. And then we do a podcast series as well. So Andy was talking about some of the complications around the guaranteed hours and 0 hours, and he did a great job of summarising that in a short time. But there's actually been 2 podcasts covering the more detail of that recently. So if that's your preference for getting up to date, you can sign up to those. And then finally, we've done a lot of online training for managers as well, not just on sexual harassment, but on the basics. And we call those our Back to Basics series. So they're a series of online modules you can buy as a suite or individually. And the flexibility of those is that they're an online resource that managers can watch either in their own time or their own work time, or together as a group of managers. And they're very cost effective and very practical. They cover topics such as disciplinary, performance management, how to recognise a flexible working request and deal with it, how to manage absence, so recognising where disability discrimination may be relevant, the difference between short-term and long-term absence. We have one on family-friendly working, so just understanding what those family-friendly rights, statutory rights that employees have. And then one thing that I'm seeing a lot of at the moment is grievances, how to manage grievances and some of the tricky issues around those. So we've just re-recorded those training modules to update them to the current legislative framework. So if you want to know more information about those, you can contact us and we'll get some information in relation to those as well. I suppose what I'm saying is, yes, this is massive change coming. And we don't know all the answers yet, but we do know what is coming up, and we're talking to clients about that. So we are more than happy to have an early conversation and help you see what might be most relevant to you or most risky areas for you. Keep in touch with us. We are here to help. We're here to help you navigate what's coming up in the next 18 months. And we'd love to engage with you if you're an employer or if you act for other businesses who may be in any of the situations I've described or wider. We would love to help you support them. We have one question, and if anyone else has got a question, we do have a few minutes to answer questions. So Lawrence, hi Lawrence, I know Lawrence, has asked the question, is the right to be offered guaranteed hours likely to apply to such roles as exam invigilators in education? So Lawrence works in an education environment. because the nature of that role is purely casual.
So
You can answer that.
So I think Lawrence sort of touched on when the work is defined as inherently temporary, which is exactly what you've sort of alluded to with exam invigilation. So of the sort of 3 bullet points I touched on when they talked about the limited term contract, so in essence a fixed term contract. So there's only a temporary work need, and the contract provides it be terminated when the employer reasonably considers that work has come to an end. So exam season comes to an end. I think that would cover off your query there, and you wouldn't be stuck in this cycle of having to do the guaranteed hours, because that would fall under one of the exemptions, the nature of the work being inherently temporary.
Brilliant, thank you. You will have a link to our feedback form in the chat box. Please, can we encourage you to just take a couple of minutes to fill out that feedback form? It's really short, and it will not take you more than a couple of minutes to do so, but your feedback is incredibly valuable. Like I've indicated, a lot's coming up, and we want to ensure that we're engaging with you and supporting you in the best way possible. So if you could just take a couple of minutes to let us know if you found today useful, if you've got any questions, if you want anything specific from what I've mentioned, we can get back to you. But as I said right at the beginning, you can contact Andy or I directly as well. So on that note, unless we've got any more questions landing in the chat box, a copy of this recording will be sent out to you, so you'll have access to the slide. You can see on the details there some of the things that I've just mentioned. Please do fill in the feedback form, and we will let you get 5 minutes back of your day. So thank you very much, and we'll see you again soon.